video should change the way that you think about giving gifts during your marriage. In a community property state such as Texas, if you are to receive a gift from your spouse, it becomes your separate property and it's not divided in a divorce case. So it's actually a powerful thing. It's quite a gift. To give your spouse a gift, it means that it's permanently theirs and you can never come back and claim an interest in that in the event of divorce. So let me tell you about a true case that happened here in Texas. Dan was a wealthy oil and gas businessman. He married Brenda in 2003. Before they got married, they signed a prenuptial agreement, and then after they were married, they changed or amended the terms of their prenuptial agreement, which is a common thing to do. And basically, the most important part of that 28-page prenuptial agreement was that that in the event of divorce, Brenda would own their marital home. She would own this 1,700-acre ranch. She would own $10 million. And most importantly, for what would become their dispute, she would own any inter vivos transfers or testamentary transfers. That means she would own any gifts that were given to her upon his death or during his life, inter vivos, during his life. So basically, what happened was they did eventually get divorced. And at the time, Dan was 87 and Brenda was 57. Now, during the very litigious divorce, they had a dispute over what you could imagine is what part of Dan's very large estate that he kept as part of their prenuptial agreement terms would now be Brenda's. And what Brenda was trying to prove during their divorce is that he gifted her a ton of money during their marriage. And so what you see ultimately happen is that Dan hires a lawyer who also in turn hires a certified bookkeeping accountant expert person. And his name is Scott Turner. And that was here in Texas. And it really looks like when you read the case that Turner's expert testimony was what won the case eventually in favor of Dan, because he testified he had reports that showed that Brenda had made numerous 30 money transfers ranging in high dollar amounts from Dan's accounts, that Brenda had transferred money from Dan's accounts to her own personal accounts. And the question is, were those transfers fraud or were they gifts that were from Dan to Brenda? And so the testimony of how the money moved by Turner was important to the jury. And what eventually happened is the jury was given this chart, and the chart shows that they had to answer as to all of these pieces of property, whether they were a gift to Brenda or not. And if they were a gift to Brenda, then that would remain as hers. But if they were not a gift to Brenda, then they had to remain as husband's separate property, because again, the prenuptial agreement said that any inter vivos gifts would remain with Brenda. So you could see what the jury awarded to her, and every part of this opinion breaks down and traces how the money moved, much according to the expert testimony that was put on by Turner. And Brenda did not have her own expert to testify as to the movement of the money that may have been, who knows, more favorable to her. We'll never know. So the case, actually, the Court of Appeals interpreted the prenuptial agreement to be unambiguous in its terms, and they defined, again, citing this case, Grimsley and Grimsley, what it is to have a gift. You have to prove that there was intent to make a gift. Now, this is what's important for your purposes, perhaps among everything more than anything else we talked about. What is it if you give a gift to your spouse, even without a prenuptial agreement? This is the case. If you give a gift to your spouse in Texas, that becomes their separate property. So if your spouse is ever asked whether that was a gift, your spouse has to prove that there was intent to make a gift to them, that that gift was actually given to them, and that they accepted the gift. Okay? Those three things have to be proven to show that there was a gift. Ultimately, the court found that all the transfers were fraud and they were not gifts. So if you're getting a substantial gift from your spouse, having it recorded that the person is intending to give you a gift in writing or even in a video with your phone is a good idea, that they're intending to give you a gift, that they have actually given you the gift, and that you accepted it. If you can make a record of those three things, if it's a substantially sized gift, that would be really smart to do along as you are married during the course of your marriage. even if you're never going to be divorced, it is a good record keeping mechanism for purposes of when you pass away, what was your separate property, to have clarity as to that. So this is good bookkeeping, if anything, to keep those things recorded. So ultimately, Dan won this case. And here at this page of the partisfriends.com website, you can just look up Hughes v. Hughes or prenuptial agreements in the search bar. But you can download this case. It's also at Google Scholar. And that's the case that shows this law if you have to show it or explain it to anybody. Thanks for stopping by. This is partisfriends.com. Have a good day.